It appears that PW11 Smith Minu was not making herself available in the court because the apprehended a danger to her life, and it was only after making enormous efforts that the trial court could ensure her presence for the purpose of a cross-examination in the court. The difficulty in procuring her attendance and the delay caused because of her non-examination seems to have caused significant effect on the mind of the trial court and for promoting it to close the evidence as the court for obvious reasons did not want to take many chance to let the witnesses slip again during the trial. Full stop paragraph. It also appears that the additional reason to take a strike view in the matter was that there was a direction of High Court to expedite the proceedings of the trial. Apparently, the order passed by the court below is such which cannot be very seriously assailed on the ground of any legality or impropriety, and the view taken by the court below can also not be castigated for being perverse. But despite this fact, when this court taken an overall broader view of the matter and keeps in perspective the imperative concept of fair trial, in the view of the court, it appears necessary that the trial should be finally decided and adjusted upon not on the basis of untested testimony of the witnesses, but after their testimonies have been tested on the anvil of cross-examination. Such a course would not only enable the court to evaluate the evidentiary value and its worth more adequately, but there shall also not be left any chance for either of the parties to assail the final verdict of the trial court on the ground that the adjustment was based on unscrutinized testimonies which were never weighted on the touchstone of cross-examination. Of course, it goes without saying that whenever the court feels that the adjournment sought by a party is not based on reasonable grounds or is actually having an oblique motive behind the same to delay the trial or to otherwise defect the ends of justice, it is very much within the powers of the court not to grant the adjournment and close the evidence, but the present matter does not display any such circumstances on the basis of which this court may come to the conclusion that the adjournment was sought for any of such reasons. The first that on which is the witness was available was 8/20/2015, and the next date was fixed as 10/12/2015. It also does not appear to be a disputed fact that the counsel who have been conducting the trial was no more counsel in the case because of his own refusal or because of the withdrawal of the instructions by the applicants. In such a situation, the opportunity of 2 days' time to engage the new counsel of cross-examine the witnesses and conduct the trial does not appear to be an adequate